Okay, welcome everyone. Welcome, Lisa. So we have a pleasure and honor to have Lisa Rogers with us tonight. Um, Thanks a lot, Lisa, for joining. Let me see. I believe we cannot hear you. Are you able to? Let me see if I can.
Hear me now?
Okay, now we can hear you.
Great, great. So thank you everyone for having me. I apologize, I was running a little bit late. Traffic back to the burbs was just really bad on 55 today. But I am excited to be here and talk about, different types of seller conveyance documents, different types of deeds. We're going to talk a little bit about title insurance, what it is, what the different coverages are, as well as 1031 exchanges. And so, Hugo, was there anything else that the group wanted to hear about before I start?
I think that those topics are going to be very critical and important for everyone. And then maybe as we move forward, then there might be some questions for you as well.
Sure. I love questions. Please use me as a resource. I let all of my investor clients know, even if you do not have a transaction currently, but you have questions, I welcome you to call me, to email me, to text me, because I want to be your partner and work with you. Your success is my success. So I just really want to let everyone know that I am an investor-friendly attorney. I have been representing investors since 2011, and it's really like what my passion is. I do represent clients on commercial transactions as well as residential, but the investor transactions are the ones that I really love doing because, and I'm passionate about because they're not always the same. There's usually a challenge, and I really enjoy growing your business. So I wanted to start off with the different types of deeds that there are. So the best type of coverage that you can obtain is from a warranty deed. And so what a warranty deed is it's a deed from the grantor to the grantee that goes all the way back into the warrant. So when I say it goes all the way back in the chain from the warrants, what that means is if there are, in title insurance, it is, let me just start there. Title insurance is completely different from property insurance. So with property insurance or hazard insurance, they're insuring for a future occurrence or a future event to happen. Where title insurance, actually, you go back in history. And what title insurance ensures is that the owner is truly who the owner is. They ensure that the taxes and liens have been paid. So they insure back on the taxes and any liens or mortgages against the property. And then they also insure the land, the name, and then if there's any judgments on prior owners, those judgments would attach. So they're also insuring the name. So when you do ask for a title insurance commitment or a policy, those are the three searches that are run. A name search on the buyers and the sellers, a land search, seeing what liens and what covenants or restrictions are attached to the land, and then a tax search to see what taxes have been paid. When it comes to taxes, when taxes are basically due when the bill comes out. So we look back to make sure all of those taxes have been paid, even if they're in the rears. And so what the different types of deeds are, it's just based on coverage. So like I said, a warranty deed, I like to think of it as like the Cadillac coverage. It's the best coverage you can get. It goes back in the warrants until it's cut off. So if there's a quit claim deed in the chain, maybe going back, a prior owner quit claimed its interest maybe like 15 years ago, the warranty deed would only go back into that point. So a warranty deed it insures the real property, the real estate, and it gives you ownership to the property. And so what title insurance does is title insurance gives you an additional guarantee. It's saying based on your title commitment and the marked up title, which eventually is what the policy looks like, we're covering these specific risks. And if anything comes up in the meantime or in the gap that was not on your policy, then you may have a title claim. So it's extra protection. It protects against fraud. It protects against certain tax consequences. And so that's why it's become a custom in nearly, I think, 49 states. I don't think Iowa actually has title insurance, but majority of states, that's why in real estate transactions, a lender will ask for a title policy to make sure that their lien is first in priority. So if a borrower does default, they're able to foreclose on the collateral or the property. And then as a buyer, it ensures that this owner who's selling to you actually owns the land. So the warranty deed is the best coverage. You'll see if you do a lot of REO transactions with banks, banks will never, ever give you a warranty deed. What they give you is a special warranty deed. And a special warranty deed just warrants the acts that have happened to the property from the time that the owner has owned the property. So if that bank foreclosed, for instance, on a previous borrower who was in default, and then they took ownership in the property, and they're now trying to convey and sell the property to a bona fide purchaser for value, they're only going to give a special warranty deed because they have no idea what is going on with the property. They have no knowledge of occurrences that have happened. So you're still getting title insurance covering you from, certain risks. But that REO seller, that bank is saying, I'm only going to give you this special warranty deed to insure you from, certain risks, but giving you good title and giving you good ownership. Tony, does someone have a question? To giving you good ownership from the time that the bank became an owner. The next type of deed is, which you may be familiar with, let me just backtrack. There's different types of deeds like trustee's deed. So what's a trustee's deed? A trustee's deed comes out of a land trust. A land trust is a vehicle that can be used in transactions to help shield the property from knowing who the true owner is, as well as shield the property from creditors. And so when you put a property into a land trust, the trustee is the entity that actually executes the deed on behalf of the owner, and the owner is the beneficiary. So it has the same type of coverage as a warranty deed, unless you get a trustee's deed, and then it says under a quitclaim deed, and we'll talk about what a quitclaim deed is. But that type of coverage comes directly from the trust to the grantee, who is the buyer, to shield the beneficiaries, and the public from knowing who the beneficiary truly is or who the owner truly is. And then the next vehicle or the next type of deed is a quitclaim deed. So a quitclaim deed, anyone, and I caution clients all the time about really understanding what is on title. So when you get a title commitment, really understanding what liens you're taking subject to, and really understanding if this person, if the fee title, so when we say this person's in title, that the ownership of this person matches who the grantor is on the quitclaim deed, because anyone can issue you a quitclaim deed. They're just giving you whatever rights they have in the property or ownership in the property, even if that's nothing. So title companies don't insure quitclaim deeds. It's too low of a coverage. And usually we see quitclaim deeds sometimes on investor deals when I see them is when there is a deal that's structured. An investor, a buyer is saying, I will purchase the property without title insurance. I'm going to take this property subject to any building code violations, subject to any taxes that are due, subject to any liens or violations on the property, and maybe even subject to a mortgage. And the owner is going to then just quit claim the property to me, and then I'm going to clean up everything on title. I'm going to probably do the rehab to cure the violations. I'm going to pay the taxes and sell it to an end buyer, or rehab it, put a tenant in it, and then maybe refinance it. So those are really I would call it the 4 different types of deeds that you'll see on a transaction. I mean, there's other probate deeds, like you could see a deed from an administrator when someone has died and they're probating their estate. And then the administrator has an order from the court to sell the property and then distribute those proceeds per, the probate order. So that's a different type of deed. And sometimes we do see those in investor transactions when someone has died and the heirs don't want to deal with the property. They just want to sell it. But those are the different types of deeds that you'll see in real estate. Does anyone have any specific questions regarding the deeds or the different types of coverage? Okay. Next is title insurance. So a title commitment is comprised.
Hello.
Hi, Eric.
Hi, Lisa. Quick question. So backtrack to the special warranty deed. So
Sure.
when the bank is trying to sell a foreclosed property to an investor, I know you said the special warranty deed comes with some limitations, but does that mean that all the liens and everything are taken care of before that special warranty deed is passed on?
Yeah. So all of those liens will be in rem or in personam. So in rem means they follow the property. In personam means they follow the person. So in a foreclosure, the in personam liens will just follow the person, and then and will be discharged. And then in rem, if there's liens against the property, those liens will be paid off by the bank, who is the owner of the property during the closing. So for instance, I just did a closing where a bank took back a piece of land that a home was on. The Village of Evergreen Park demoed the house that was on it because it was not in good repair and it was a safety hazard. And then they slapped a very large, like $60,000 demolition lien on the property. At closing, the bank paid that lien off because the bank, even though they're giving a special warranty deed, they still need to give clear and marketable title.
Okay, great. Thank you.
Yes. Does anyone else have any questions? Okay. Going forward, so with a title commitment, when you take a look at a title commitment, you'll first see what's called Schedule A. On Schedule A, that tells you who the proposed insured is. So the proposed insured is your grantee buyer. If there's a lender, it will show the lender's name and information as well as how much they're lending. And then it will show who the title is held in. And that is the most important because the title is held in the owner. And so we want to make sure that the owner matches, the deed that's being conveyed out. Sometimes you'll see on investor deals, someone will contract like in their personal name, but they owned it in an entity or vice versa. That can be easily changed with a contract amendment. And next is the legal description. So after the exhibit, you'll see the legal description. We convey real estate by legal description, not by address and not by PIN. So if your legal description is not correct, you don't technically own the property even if the address is on there correct or the PIN. So the parcel identification number that is always, part of the legal, that's to help the county out when they post documents to make sure that the documents are posted properly against the correct chain, as well as that number obviously is used by the county to assess taxes to the correct property. And then the address is really used for the postal service and for mail, even though an address is attached to a legal description. Sometimes when you see like large commercial deals, you'll see lenders asking for, legals to match the address because they want to make certain that that property really, that address really goes with the legal. And really important that whatever attorney you use, that they are checking those legal descriptions against the survey as well as the deed, because we want to make sure that the correct property is being conveyed to you, or the correct property is being, conveyed out by the owner or the grantor. So after that, after the Schedule A and the legal description, the next schedule is Schedule B1. And on B1, this lists the requirements, the actual specific requirements to the property in order to close. So depending on, for example, what jurisdiction you're in or what city or municipal city you're in, there's going to be specific municipal requirements. Some villages require inspections. Some villages require bonds to be held up. Some don't. Some require just water and transfer tax. Water or their transfer tax to be paid, as well as if there's outstanding liens, those need to be paid. So it's really important when you're contracting to really understand what those costs are and to add those into your calculations and closing costs, because sometimes it's hard to do a rehab if a tenant is in place, or it's hard to take the property because there maybe is like an as-is compliance document and you have to rehab within 60 days. So all of those are really important considerations to take in mind when giving offers. Getting back to Schedule B1, if there's a mortgage recorded against the property, you'll see that there's a mortgage, the exception for the mortgage, and that mortgage obviously at closing we'll get a payoff letter and it'll be paid off to the lender, so the buyer has clear title. Also, some other things that can be recorded are court cases if the property's in foreclosure, if the property is, if there's a building code violation case. In the city of Chicago, you'll see that as a municipal case, as an M1 case. With that, you would have to review what the complaint is saying and what specific violations need to be cured, as well as going in and working with the inspectors and corporation counsel to make sure that you're doing everything to make sure that the property is put back into a safe condition. Something else that is on Schedule B1 is if there's any type of like bankruptcy or judgment against an owner or buyer, that would be the place where you would see them. And then Schedule B2, you're going to see your standard exceptions, which have to do with like mechanic liens, surveys, encroachments or encumbrances, if there's tenants in possession, and then gap coverage, and then taxes. So what taxes are due and owing, what taxes are delinquent. You don't ever want to take title when taxes are delinquent, unless it's a very sophisticated investor and the transaction is tailor-made to that specific instance, which I've seen that before. Also, what you'll see are covenants, conditions, and restrictions that run with the land. Those types of exceptions cannot be waived off of title because they do run with the land. So we want to pull those documents and take a look at them to make sure there's no restrictions or prohibitions in them that would violate like your use. I also just want to bring up that if you're not in the city of Chicago, you always want to check like the zoning or do like a freedom of information, a FOIA request, just to make sure if you're, make sure that it is like a legal 2 unit or a legal 3 unit, or if you're looking to do something else with the property and completely change the use, that under that zoning code for that specific town or city, you're able to do so. So that would be that would be my, description of a title commitment. So as an attorney, we review your title commitment, and if I'm a seller, I go through the title commitment, and that I need to waive the exceptions that the buyer would not want to take subject to. So meaning that they're not going to take subject to any of the seller's liens. They're going to want clear taxes. They're going to want the mortgage to be paid off. Sometimes with investor deals, a buyer will take subject to a building code case because they're getting a construction loan and they're willing to cure those violations. So in that instance, it would be fine to take subject to a building code violation case if you were a buyer. But we get all of those documents together, we furnish them to the title company reviews them, puts the proper figures into the settlement statement, and then we waive title to give marketable title to the buyer so they're able to move forward and rehab the property, or work with the property, maybe working on getting tenants into the property, to whatever your end goal is. Does anyone have any questions regarding title commitments or waived title or marketable title?
Hi, Lisa. This is Sam. Can you hear me?
I can. Hi, Sam. How are you?
Very good. In some of this closing document, I see title examination fee, 500-600, and then a few lines down it says re-examination of the title. So what is the examination of title? What is the re-examination of title?
Sure. So I would say that I haven't seen, and if you want to like after this meeting, send me your settlement statement and I can set up a call with you and review it. Because it just seems like that title examination fee is a little bit high at $500 to $600. Typically what we see is a title examination fee being anywhere between $250 and $350. So that is actually what I was saying with the three searches. There's a name search, there's a land search, and there's a tax search. And those searches come back from the county, and then the examiner who's actually putting the title commitment together actually pulls those specific documents, and they do what's called an examination. And they examine those documents to see if, they really run with the land, they really need to be raised on Schedule B2, if the liens have been released. Like they look through the exam and they go all the way back. They go 40 years back on the search, and they really look and they do a full examination of that search and then type it to put it into that title commitment format. So that's what the examination fee is. I'm not sure why they would ever have a re-examination fee. I've been doing this for 15 years and I haven't seen a re-examination fee, but that doesn't mean that it's not proper. I would, if you'd like me to take a look at it, I'd be happy to do so.
Sure. Yes, sometimes probably they didn't charge at the first time. They charged for the second time.
Yeah. So was it a deal that and I'm sorry, I didn't mean to interrupt you. Was it a deal that maybe you had kind of like lingering for a while and then it finally closed? So maybe some time went by during like the gap period?
Not really. It was 3 days waiting period in between. It wasn't that long to need another search. But
Sure.
I was thinking that maybe the lawyer is trying to help himself just to make a little more money.
Maybe. I mean, I don't know because I haven't seen it. But I'd be happy to take a look at it and discuss it with you offline.
Sure. No problem. Thanks so much.
You're welcome. Any other questions? I see that Joe and Richard are on this call, and you guys called me a day ago, so I wanted to say hi, and I need to follow up with you.
I have a
Well,
question. I don't know, maybe you answered it earlier, but what's
sure.
the difference? Yes, what is the difference between the title and the deed?
Sure. So a deed is the actual document that conveys ownership. So
Okay.
a deed is something that you can hold in your hand and you can say, you can show anyone, I am the owner. The deed is a piece of paper. It's usually 2 pages. You'll see it has like the conveyance clause at the top. It gets recorded in the county. You can see the stamp at the right-hand side. It then recites the legal, the PIN, the address, and then some legalese, and the seller will sign it, okay? And then the second page is the notary page, where the notary attests that the person signing it really is the person. They've looked at their identification, and then it has, you know, where the deed should be mailed after it's recorded to the new buyer, and where the tax bills should be mailed out. So that 2-page document is a deed. It's a seller conveyance document, and it's what shows the public that you own the property, that you own the real property. Okay, so that's what the deed is. A title commitment is an insurance product. So it's showing you, it's basically like telling you a story of the history of the property, looking back at the property, who the owner is, who, through the effective date. And the effective date is when the title has been searched. So it looks back from the effective date back. So if I'm searching title today, for example, it's October 19th, if I pulled a search right now, my search would probably be only good through, let's say like October 11th. And why is that? Because there's a gap in the searches, which means there's a real-time gap. So if I go to the county today and I record a deed today on October 19th, we're not going to see that deed's recorded until about October 30th. The gap is anywhere between 7 to 10 days. So then what we do is with the title is we look back. So from October 19th, right, we look back in the warrants or in the title, and looking back, we're looking back at the searches, and we go 40 years back. We research 40 years on the property, and we look back at the name search, the tax search, and the land search. And we look at everything that has been recorded against this property, and we raise only like the liens. We raise who the owner is, any liens against the owner's name. We raise any restrictions or covenants that run with the land, any taxes that are not yet due or payable, and taxes that are delinquent. And we put this in a report. And this report basically tells the investor the story of the property, and it lets you know if, you know, your attorney needs to clear, like they have like a lot of work to do to clear the title, because the title could be messy, or it could be a very clean and simple title. And so the reason why people get title insurance is it insures them from any risk. So any like fraud, you know, if there's like a wild deed in the chain, someone just decides that they're going to quit claim this property to you, but they really aren't an owner. That would be called a wild deed. And it really, you know, it would be raised on Schedule B2, and it really has no reason to be there, but we would have to explain that because we want our chain to be clean. Does that answer your question?
It surely does. So pretty much the deed shows ownership and the title shows the history, and, you know, goes through the history and everything goes with it. So I got it. Thank you very much. I appreciate that.
You're welcome. Does anyone else have any questions? Okay, so I'm going to go on to talk about 1031 exchanges. And the 1031 exchange is a very, very powerful tax tool that I employ every investor to use if it makes sense and if it works with what you're trying to achieve. So a 1031 exchange allows you to defer taxes on properties that are not your primary residence. So if you are in the business, which we all are, of making money, and you purchase a property, and let's hypothetically say you rehab that property, and then you flip the property, you're able to find an owner or a buyer who wants to purchase the property for a profit, and let's say you make $50,000 profit on that property. Depending on what your tax basis is, that can be taxed anywhere between 20 to, all the way up to 40% on that 50,000. And so what a 1031 exchange does is it lets you defer those taxes that are due and owing, and it lets you roll them into your next investment. So you need to identify within a specific amount of time 3 properties before you have them under contract as your 1031 exchange properties. And then there's some documents you work with the 1031 exchange company and your attorney. And once you get that property under contract, you're able to use the funds, the capital or like the profit that you've made from your first rehab and not pay taxes on that and roll it into your second rehab. So you're able to, instead of paying the government, there's 20, 25, 30%, you're able to roll that into the next property and, keep going. You can basically keep going until your entity ceases or until you die. Once you die, then those taxes will come due.
Yeah.
Does anyone have any questions on a 1031 exchange?
Yeah,
Hi,
Lisa,
Lisa.
for the taxes once it comes due and after you die?
What?
Who will become liable for the taxes if you die?
Sure. So your estate. So you're only, if your estate has significant money. So let's say that you keep doing these rehabs and they get larger and larger, right? You start off hypothetically with a single family home, and then you the next time hypothetically you do a 2-flat, and then you go to a 3-flat, and then a 4-unit, and then an 8-unit. So we're making the assumption that you are continuing to make money and continuing to make capital gains, and you're continuing to develop properties and rehab properties. At that point, if you were to become deceased and there was a large estate, then the estate would have to pay taxes. Your heirs would have to pay those taxes. I mean, there's really, there's 2 things that are absolute in life, and one of them are taxes. So it's not a method to eliminate taxes that are due, but it's a method to defer the taxes that are due. So you can use that money to go into your next project and grow your business. I mean, if you're looking for ways to absolutely eliminate taxes, there are certain products out there like cost segregation analysis, which we deal with depreciation. There's a lot of stuff that's in the energy code with the Inflationary Act that President Biden just passed. So there's 45L, there's 45Q, but those are tax saving tax saving strategies that you use on like much bigger projects. It probably wouldn't make sense unless it's like maybe like 6-unit, and then if you're using like a 45L or a 45Q, you need to be really following like what that environmental code is. They have strict laws about what you need to do in order to qualify for that. But the great thing about something like that is if you do qualify for every unit, you get a $4,000 credit. So that's a way to like limit your tax liability, like truly limit it and not defer it like a 1031 exchange.
Interesting. Thanks, Lisa.
And if you want, I do know someone who does this as a full-time job. So for some of my like larger commercial clients, I refer, they work for an accounting firm, and I, refer that business to them. If the group is interested in learning more about those types of tax strategies, Hugo, I'd be more than happy to set up a call regarding that, and maybe doing a call with them.
That'd be great. So we should be able to schedule another webinar just to go over 1031 exchange.
Yeah.
That's a great idea.
We could do like 1031 exchange, the differences between that as well as like cost segregation analysis. Basically, they depreciate all of the personal property and the real property versus the real property. And, when they were saying, wow, there was this like whole debate when President Trump was in office that he was like not sharing his taxes because the implication was he was paying zero taxes, but he was like this real estate developer. How is that possible? Well, it's possible because he's using those types of strategies, right? Those types of tax saving strategies. He's using, 45L, 45Q. He's using cost segregation analysis. There's a whole line of products that really I would like to try to educate more people on because I feel like only a certain, you get to that certain level and, the general public really doesn't know what's available to them.
Hey, Lisa.
Yeah.
Hey, this is
Hi,
Chris Cash. How you doing? Hi. I got a quick question for you. I'm good. Quick question about 1031 exchanges. Is there a certain amount? I mean, you only have a calendar year to use those 1031 exchanges, and then if you pick, then let's say you have another property or two that you want to invest in, you have to pay for those first, right? Before you can use the 1031 exchanges to pay for those, or is there where you can roll like the payments into another one before you buy it? Does that make sense? The questions I have?
Yes. So you only have 180 days from identifying the property to basically close. So it has to be like very, like you have to identify, and then you have, 6 months to close. If you don't close by that date, you don't get the benefits, the tax benefits of the 1031 exchange. I do, and I have to research. I understand what you're asking, and I'm not like I've done 1031 exchanges for clients, but like this would be a question that I would ask the 1031 exchange company because we work very closely with the intermediary. So like your capital gains would go into there. They would issue the forms that both like the buyer and the sellers would have to sign. And it's like I'm doing like I'm closing on like 15 properties on Tuesday. My client is an investor who's purchasing, and he's actually purchasing out of a 1031. So the seller is part of a 1031. So there are certain intricacies. I think if you identify like within those 3 properties and you still have like leftover capital gains, you can still use that money on the 2 others that you've identified, but it has to be within that time frame. It has to be within the 180 days. But if you have more specific questions, I mean, I'm happy to, I work very closely with a 1031 exchange company. I'm happy to share that information and do an email introduction because, they'd probably be a better source for you. But that's basically like the basic gist of it. Oh, I can't hear you.
Oh, I'm sorry, I muted you. Is your contact information anywhere on the screen at all? Like an email or anything like that, or no? I can't see if it's there.
I can give it to you.
Okay, that's fine. I'll write it down. Thank you.
And I have a couple questions here, but I can give you my email. So it's Lisa, Lisa, at A is in arc, R is in rain, K is in kite, laws, LAWS.com.
Thank you, Lisa. I appreciate it. So I'll take up so much time.
You're welcome. Brian, I just want to go through some of these questions. So Brian asked if I'm a CPA, and I am not a CPA, Brian. I am a licensed attorney in Illinois, but not a CPA. So that's why I say if you have very specific questions about a 1031 exchange, I'd be happy to share that contact information with the group so they can follow up directly with the 1031 exchange company. And then Veronica asked, with the 1031 exchange apply, do we need to flip the property right away? You have 180 days, Veronica, to consummate the transaction. And then I have another question from Dwayne. It says, does it matter how the property is held, personal or corporate? It does not. You could do a 1031 exchange in your name or in an entity to shield from liability. I always tell investors to either form a limited liability company, shield the property, or put the property in a land trust, or form a corporation. And so if you have specific questions about those entities, I'd be happy to answer that as well. So I just wanted to thank, if you have no other questions, I just wanted to thank everyone for taking time out of their busy schedules to listen to me. Again, please use me as a resource. And Richard and Joe, thank you so much for just putting that on the screen. I really do. I'm really passionate about working with investors and helping everyone to become successful. And so I really do welcome any questions you have.
Lisa, I have a question. This is Sam.
Hi, Sam.
I'm a real estate broker. Sometimes at the cash closing, cash deals, I see some of the cost is split between the buyer and seller. So that's normal, correct?
That is normal. So
Okay.
on a cash transaction, the escrow fee is split between the parties. So the seller will pay half and the buyer will pay half. When there is a loan, the buyer pays the full escrow fee.
Okay.
Unless you're doing a wholesale deal and the parties agree that the buyer pays for all closing costs, then all the closing costs would be shipped to the buyer's side.
And in some financing deal, I see the other attorney reaches out to other side of the transaction for some fees. For example, the seller lawyer charge something on the buyer side, or the buyer side lawyer charge something on the seller side.
Sure.
Is that normal?
Yeah, so that's a great question. So the attorneys are not charging. What the attorneys are doing is the attorneys are agents of that title company. So the attorneys share in the title company's fees. So those fees are charged. For example, you're probably talking about, like, on the buyer's side, you'll see a loan policy, and a loan policy for $550. And then you'll see the seller's attorney's name next to that charge. What that means is there would always be a charge for a loan policy. The title company isn't getting that revenue, that $550. It's going to the seller's attorney. So the seller's attorney isn't charging it, the title company is charging it, and it's a normal and customary charge. They're just disclosing to you that the seller's attorney is being paid that fee. Or another example of a fee like that on buyer's side would be an endorsement charge.
Okay. Yes, and does the title company normally control these charges? Because sometimes I see bogus charges in either side, and I see the fax, the charges, email charges, and some other charges. So is
Yeah,
that normal
so
also?
those are all normal charges. So the email charge you'll see typically on like a loan transaction because there's a loan funder and then there's a closer. And so you would be shocked on how many emails those two individuals have to kind of go back and forth to get a package approved. So they're emailing from inception of the transaction to during closing, trying to get approval from the lender that everything is signed properly, everything is initialed, dated correctly, that figures are correct. When figures go into a settlement statement, the seller's attorney provides the seller's figures to the title company, and then the lender, if there's a loan, will provide loan figures to the title company. And then the escrow officer takes those figures, both figures from the lender and the seller's attorney, and they put them into one master settlement statement. And then the lender, the buyer's attorney, and the seller's attorney review that statement for accuracy.
Yes, sometimes I see wire transfer fee. Although
Yeah.
the buyer goes to the bank, pays the fee to transfer the money to the title company, but I don't know what is that charge for.
Sure. So a wire fee is typically $50, and that's because the banks are actually charging that amount or somewhere near that amount to the title companies. And so that's for, if you're a buyer, that is because your lender has wired in their funds. So even if you brought in a cashier's check, the lender has wired in your funds.
Yes.
If you're a seller, there's going to be a wire fee on your side as well, because if you have a mortgage that you need to pay off, the payoff has to go out as a wire. So you'll see it as a wire. Now, if these are cash deals, you don't have to have those wire fees. If the seller doesn't want proceeds, they can take a title company check instead of a wire. If they're not doing a payoff, then there's no need for a wire fee. On the buyer side, sometimes you can't help it if there's a lender. The lender's going to wire in their proceeds. And then for a buyer, anything that's $50,000 or more under the good funds law in the state of Illinois, you have to wire in. It has to be liquid good funds. So anything from $0 to $49,999 you can get a cashier's check. But if it's $50,000 or over that you have to bring to closing as a buyer, then you have to wire it in, and you'll see that wire fee.
Great. Last question. Your practice is mainly in real estate, right?
That's my total practice. I'm a transactional real estate attorney, so I represent clients on commercial, residential transactions. I negotiate contracts for them and go to closings. So that's what I do with 100% of my time.
And you cover all the counties, right?
All the counties, yes. I cover the state of Illinois. So I'm licensed in the state of
Illinois. Yes. Very good. Thank you so much. If you don't mind to share your information on the chat so everybody can see.
I'm going to put it up right now.
Thank you so much. Have a good evening.
Yeah, you too. Does anyone else have any questions?
Yeah, I don't see that people have any other questions.
I'm going to.
Okay, perfect. So thank you very much, Lisa, and thank you everyone for joining. That was great information, very helpful. So please feel free to reach out to Lisa. She just posted her email on the chat. There's one more question from Brian. Do you charge flat fee when you represent a client?
So on an investor deal, I charge a flat fee of $850. If it's a residential deal, then I charge $750.
Perfect. Great. Okay, so thank you very much, Lisa. I appreciate joining us tonight. It's great seeing you again. So everyone, please feel free again to reach out if you have any questions, and I look forward to seeing you all in our next webinar or live event. So thank you, Lisa. Have a wonderful night, and we'll talk soon. Okay, thank you, everyone. Have a good night.